13% probably would be my take. 99%, yeah, just like your masks, right? And the jab and all the other things. Does he have a citizenship card over there? No, I checked under there. What about over there? No, I checked over there. What about over there? That too. He's not a citizen. Send him another notice, then keep him on. And the government says they're coming back. The district court ignored their failure because they claimed that they didn't have enough information to sue because Virginia stonewalled them. Oh gosh, yeah. That's a good valid reason to sue someone. An emergency stay is what many states are asking at the Supreme Court, knocking on their door saying, can you please step in and do something about this? There will be over 1,000 non-citizens, people who should not be on the voting rolls in Virginia. We know that the law has been in place for a long time, saying that they should be precluded from voting, and the government is fighting to keep them on. In fact, the Biden-Harris administration is fighting to keep them on. And so this is now submitted here from our friends in Virginia, the Office of the Attorney General in Virginia, but they're not flying solo. They've got 26 other states who are joining them in this. And so we're going to poke through both of these filings at the Supreme Court, waiting for Judge Roberts to give us some clarity on what comes next. And here's what they say. To the Supreme Court of these United States on the eve of the election, they say, all right, listen, SCOTUS, this is a pretty serious situation here. Less than 2 weeks before the 2024 presidential election and more than a month into early voting, the district court below ordered Virginia and our officials, they ordered us to place over 1,600 self-identified non-citizens back onto the voter rolls. Okay, people who've told us they're non-citizens, they say, yeah, put them back on, in violation of both Virginia law and, in case you're wondering, common sense. About 600 of these individuals personally told the DMV they're not citizens, and about 1,000 presented non-citizen residency documents to the DMV, who were then positively identified as non-citizens through the government's own SAVE database. We looked it up with your computers. The United States itself has explained that SAVE is accurate 99% of the time, right? That's from their Government Accountability Office. What do you think that means? Like, if they say it works 99% of the time, what do you think it is in terms of like actual accuracy? You just had to guess. 13% probably would be my take. 99%, yeah, just like your masks, right? And the jab and all the other things in 14 days. But the district court based the injunction, which mandates a variety of disruptive measures, meaning that they're shoving them back on the rolls. The district court said, put them back. They said they're making us do this, and they're mandating a whole bunch of new problems. Like, it's going to be very disruptive to force non-citizens back onto the ballot on a provision that doesn't even apply. And even if it did apply to the removal of non-citizens, Virginia's program complied with it anyway. So you're trying to use some weird law to force us to put these people back on. They're not supposed to be on there. This election eve injunction is based on legal error, Supreme Court, and the injunction, which prohibits the application of a law that's been on the books since the Justice Department said it was fine in 2006, will injure Virginia's sovereignty, confuse her voters, overload her election machinery and administrators, and likely lead to non-citizens to think that they are permitted to vote, which is a criminal offense that will cancel the franchise of eligible voters. So the DOJ approved this a long time ago. These people confirmed they're not citizens. They're using some law that does not even apply to the removal of non-citizens to put them back on. They're trying to shove round peg into a square hole. We took them off because we cannot do that. We have to, sorry. This mandatory injunction, this enforcement, this requirement violates this court's Purcell doctrine. And we know the Purcell principle has been coming up a lot lately. And this is the idea that federal courts shouldn't take action against state laws when there is a pending election. Don't interfere with the election when we're close to the election. It's the Purcell principle. This court has repeatedly instructed that Purcell bars federal courts from enjoining state election laws when an election is coming up. All these cases, so you did it there, and 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 there, and there, and there, and there, neener, neener, neener. And so this principle recognizes the critical interests that state officials have in protecting their election and avoiding voter confusion. Why are you trying to shove these people back on the polls right now? You can't do that. The Fourth Circuit refused to apply Purcell and declined to stay the injunction, holding that appellees do not challenge a state election law, and that Purcell is inapplicable here to the federal law. So saying you're applying the federal law, I'm not imposing upon your state law. Now that ruling is also incorrect and also violates this court's precedent. The district court enjoined the enforcement of Virginia law. They weren't impacting on federal law, right? Purcell would apply the federal courts not interfering in the states. So the federal court, in order to get around that, just said, I'm not interfering with the states. I'm only interfering with the feds. And they say, well, no, you're not, because you're clearly stopping us from complying with our state code. It's our sovereignty to make sure our elections are legitimate. And Purcell applies to 11th hour injunctions under the federal laws, particularly where, as here, they order mandatory retrospective relief of adding numerous people to a state roll past the deadline for doing so and shoving them on right before an election, for crying out loud. And so applicants thus move, Supreme Court, will you please hear us and listen to us, please? We're knocking on your door. For an emergency stay of this order to put them back on. Because the district court ordered us to comply with the injunction, we respectfully request that the court issue a stay by Tuesday, which is today, and that the court issue an immediate administrative stay to permit the orderly resolution of this motion. This relief is not available anywhere else because the Fourth Circuit has denied the requested stay, meaning they issued an order, put them back on the rolls. They said, can you please stay that order while we appeal to the Supreme Court? They said, no, they're going back on the rolls. So they said, okay, now can you, Supreme Court, then order them to stay it so the voters don't go back on the rolls so that we can resolve this? The district court issued an order enjoining enforcement, so stopping us from removing the voters. The district court orally denied the motion to stop the injunction pending appeal. And so we filed this emergency saying, help us right now. Okay, the election's like right around the corner. Are these votes going to count or not? They say, all right, listen, 9 Supreme Court judges. This should be pretty obvious to you, even you, Sotomayor. Based on its finding that the right of citizens in the United States to vote is a fundamental right, Congress passed the NVRA, the National Voter Registration Act. What does this do? The law says, quote, eligible citizens should be voting. To promote eligible citizens and their participation in voting, they require each state to establish procedures to register to vote by application made with an application with their driver's license. The procedures say each state, so Congress is mandating to the states, each state shall, mandatory, ensure that any eligible applicant is registered to vote in an election. Eligible. If the valid voter registration form of the applicant is submitted to the state MVD, then they're registered. But again, they've got to be eligible and added to the list of eligible voters. Who was eligible? Citizens. Now, at the same time, they also required states to allow eligible applicants to register. It imposed restrictions on removing these, quotes, registrants from the rolls. Under the NVRA, a person who is an eligible applicant and has submitted a valid registration may not be removed from the official list except in 4 circumstances. Here's a couple. Voter request, death, felony conviction, mental incapacity, change in voter residence. In addition to those, there's a blanket ban, but there are the exceptions. The NVRA also contains a special prohibition on certain removals close to federal elections. There's a quiet period provision as well. It incorporates other things. So to ensure that the Commonwealth in Virginia and that their rolls remain clean, they're giving us the rules, while also complying with the federal rules, here's what Virginia did. We're trying to fit it into all these statutes. So we amended our election code all the way back in 2006 to require the DMV to send the information of any individual who declares himself to be a non-citizen on a DMV form to the Virginia Board of Elections. Then they check that person's information against a system to ensure that these self-declared non-citizens are not mistakenly included on the voter rolls. Only if there is a match does elect forward the information to local registrars to continue the verification process. Now, the policy is to send local registrars only the records of persons who affirmatively and contemporaneously declare they are not citizens on a form. It did, however, also recently work with the DMV in an ad hoc review of records to ensure that persons who engaged in transactions and who had documents on file showing non-citizen status were not improperly on the voter rolls. So they do it as they come through, right? As they're processing somebody, they check. But they also just went and just kind of did a check. So from July 1 to June 30th, 1 year basically of reviews to accurately ensure that any such individuals who had subsequently become naturalized citizens, right? They file paperwork saying, I'm not a citizen. Then they become a citizen. They check, oh, are you a citizen now? Okay, well, we're not going to remove you automatically. So we check. So the DMV ran these individuals through the Homeland Security Save database, which, as we've seen in other lawsuits, is mostly garbage. I think Ohio said we can need access to more. You can't even search by name or date of birth in the Save database. So you have to use like an immigration number, which they're probably getting because these people are adding it when they're going to the DMV. The Save database shows whether a legal alien resident has subsequently obtained citizenship, right? So somebody they already have on record, they've got a number, they look them up. Only those persons registered to vote who had non-citizen documents on file with the DMV and who also were confirmed as current non-citizens were then transmitted to local registrars to act upon. Then the transmission of the information occurred in late August. The individualized approach, meaning they're checking every single person, which confirmed non-citizen status with a Save search within the previous 30 days, ensured that no naturalized citizens would be removed. Okay, so one thing you want to be concerned about, it's not overbroad. You don't want to get a bunch of actual citizens who should be allowed to vote thrown off the rolls. So they're being very clear. And they found 1,600, which means the number's probably much bigger than that, at least 10 times, maybe 100 times bigger than that, especially in places like Arizona, where we have a bucket of 200,000 that we admit are questionable. When elect finds that a person who has declared himself to be a non-citizen on a form or has failed a recent save search, they send the person's information for review. The law requires registrars to delete the name of any voter who is known, Virginia law, this is mandatory, it's in the law, delete the name of any voter who is known not to be a citizen by reason of self-declaration or from elect or save. And so they manually review each match on an individual basis to confirm the non-citizen and the registered voter identified are the same person. And they have the discretion in this process to correct errors, such as that the person identified in the DMV file are not the same individual, happens a lot, or that the registrar has superior information on a person's status. If they determine that the non-citizen and the registered voter are the same person, then they'll mail the person a notice of intent to cancel their registration. Wow. Then they say, hey, we've got information that you're not a citizen, and please affirm within 14 days that you are a citizen, so they get a warning. If the recipient fails to return the affirmation within 14 days, he sent another notice saying, you're gonna be removed. Hello, give us a call. By default, Virginia also provides a grace period and does not actually cancel registrations until 21 days later, until they're like, I'd never go to the post office. I mean, who does that? Even if the person fails to respond to either of these notices, he can still re-register with no impediments. Even after their ordinary registration process closes on October 15th, he can use in-person same-day registration to apply and vote if he is in fact a citizen. Let's say 2 warnings plus a grace period, and you can register on the same day if in fact you are a citizen and there was a mistake. Now, the Youngkin order was issued August 7th. It did not create these long-standing processes, okay? Youngkin didn't make this up. The order simply required the DMV and the elect databases to share their data on a daily basis instead of monthly, and to certify that they're following the law already. You just say, just follow the rules. That's all. And this stuff was all created ages ago and already pre-approved by the DOJ, the same DOJ that's suing them now. So the plaintiff in these consolidated cases, the people who sued, are the United States useless government and an assortment of advocacy organizations, okay, which are lefty liberal groups who want non-citizens on the rolls. Ask the district court to inject itself, ask the federal government to come into Virginia and mess with their elections. Within 1 month of the election, weeks after early voting had already begun, and they asked the court to order Virginia, our federal government ordering a state, to restore voter registrations of canceled registrants, non-citizens who you saw. It's not like this was an accident, okay? They identified 1,600 people. They scrutinized the heck out of them. Check here, check there. Are you sure? Does he have a citizenship card over there? No, I checked under there. What about over there? No, I checked over there. What about over there? That too. He's not a citizen. Send him another notice, then keep him on. And the government says they're coming back. The court first concluded that Purcell actually supported adding them back. They said you can't remove them because it's too soon. They said that the quiet period applies to non-citizens because the NVRA contains no explicit exception for them, and that Virginia was systematic. So they said, no, sorry, you should have removed them earlier. At the same time, the district court held that non-citizens could be removed under the general removal provision, despite that provision not containing an explicit exception for them either. And so balancing the equities here, Supreme Court, the district court relied on hearsay and a smattering of anecdotal evidence to conclude that Virginia's program would cause irreparable harm and was against the public interest because that evidence showed that only that the self-identified non-citizens it ordered Virginia to put back on failed to return a form and attest that they were citizens. That's all they did. We're not going to remove them because they didn't send letter back to you in the mail. That's not why they were removed, because they didn't respond to a form. They didn't say, are you a citizen? It's like a, Valentine's note, like, will you go to the prom with me? Yes or no. Or to the dance with me? Yes, or circle one. Yes, no. They didn't send that to them. Are you a citizen? Yes or no? No. Oh, great. You're not. I'm going to pull you off the rolls. No. It was multiple redundancy checks to validate the decision. And the judge is like, well, they're not going to return a form. Thus, on October 25th, only 10 days before the election, the district court, a federal judge acting on behalf of the Harris-Biden administration, ordered Virginia to within 5 days restore 1,600 self-declared by federal government databases confirmed non-citizens back on the rolls. It's crazy. Initiate a mass mailing notifying them that they'd been put back, promulgate guidance for local registrars, issue public statements retracting the mailed cancellations, educate poll workers about the order, track the poll workers' training on this order, and then they denied the stay of all of these requirements. So you're going to go unring this bell rapidly. So then we moved later that day for a stay stay from the Fourth Circuit. We said, we're going to appeal this. This is crazy. You're going to make us put non-citizens back on the rolls and then tell them that they can vote, essentially. The cancellation is canceled. The Fourth Circuit denied. They said, sorry, the Purcell principle is inapplicable because it's federal law. The NVRA, the federal law, talks about the quiet period, and it would necessarily mean that the general removal provision prohibits the removal of non-citizens. That's too close to the election, and so rejected. So the removal is canceled. The people are coming back on the rolls, according to the Fourth Circuit, which is why we are now here at the Supreme Court. So they say, look, all right, Supreme Court, listen, this is obviously nuts. We are here. We're asking for a stay because we think one will be granted. If there's a reasonable probability that 4 judges will consider this issue meritorious, then we can move forward. If there's a fair prospect that the majority of the court will reverse, and if there's a likelihood of irreparable harm that will result if you deny the stay. So if you make them or allow them to put these 1,600 people back on the rolls and get ballots and have their votes counted, there will be irreparable harm. So the question for us, are there 4 judges? Remember, there are 6 conservative judges with squishy John Roberts, who we never really know what he's going to do. But will 4 judges think this? Will they think that they'll be able to convince another judge to join them in order to reverse this? And do they think there will be a high likelihood of harm? I actually think that there's a good chance of that. Amy Coney Barrett gives me pause. But this court has applied more searching review of election eve injunctions. It has stayed injunctions against state election officials issued close to elections before. You've done this before, so don't act like this is too soon. Here are some reasons for this stay. The district court entered a burdensome mandatory injunction. They're forcing us to go put these people back on the rolls and to educate them and to buy them snacks on the car ride to the polls. On the eve of an election. We haven't even gone to Costco yet. Now, the injunction is based on misinterpretation of the NVRA, which does not prohibit Georgia from removing people. And they're not going to suffer any injury here. If we remove these people, the government's not going to be harmed. Virginia's process removed non-citizens. They're not eligible to vote, so no one's going to be harmed. To the extent that any individuals misidentified themselves as non-citizens, if they're like, oops, I actually am a citizen, I made a mistake on that one, and then failed to attest to their citizenship upon the registrar's request, any individual can still just go vote on election day. Just show up there and vote. I'm a citizen. Oh, great. Sorry about that. Here you go. Virginia's law has been around forever, and both plaintiffs, the DOJ and the liberal groups, unduly delayed bringing this lawsuit. Virginia's law creating this removal process has been in place since 2006, you punks, and plaintiff waited until 60 days into the 90-day quiet period, less than a month before the election, before bringing the suit. The mandatory injunction will also impose significant costs, confusion, hardship upon Virginia, creating an influx of work for its registrars and other people critical before the election. It's going to also confuse non-citizens into believing that they are actually eligible to vote. They are. They're going to get ballots and their vote will count if it's submitted. So they are eligible to vote according to the current order. Finally, if this court considers the likelihood that it would grant review and reverse the lower ruling, it's likely to do so. Court of Appeals have disagreed as to the proper interpretation of these provisions, and the court below erred on this question. And so the court should therefore accept this case, grant a stay, and stop this from going into fruition. They talk about the Purcell principle, which is this idea that the federal courts will not interfere, and it applies right now. And therefore, the DOJ, Biden-Harris, they can't satisfy it here. They cannot show that the merits are entirely clear-cut in their favor. In fact, to the contrary, the merits decisively favor Virginia. Several federal judges have concluded this in this case, and this case, and this case. Here, it says Congress did not intend to bar the removal of names from the official list of persons who were ineligible and improperly registered to vote in the first place. You don't make changes that are going to impact the people who are participating in the election. It's not applying to people who are not supposed to be participating in the election. It doesn't apply to the removal of non-citizens, okay? The quiet provision says that it doesn't apply to them. Their registrations were void from the beginning, void ab initio. From the inception, their registration when filled out is invalid. So it doesn't apply to them. Virginia's removal of non-citizens, therefore, did not violate the law. When we interpret a statute, the court is brought in to interpret the ordinary meaning of the phrase. Section 8 talks about eligible applicants. An eligible applicant becomes a registrant through proper mechanisms. And so the removal restrictions are stricter in the 90 days, when at that point, it prohibits systematic as compared to individualized removal programs. And they didn't do a systematic removal in Virginia at all. The NVRA doesn't prohibit the removal of persons like non-citizens and minors. They were never eligible to begin with. with, so they could never become a registrant who is subject to the law. The law protects registrants. They are not eligible registrants. This understanding of the text is confirmed by its structure, and that's clearly what it means, saying this error alone is sufficiently important for this court to grant the stay. Not only would such a restriction on the state's removal power be facially absurd, right, by saying you cannot remove non-eligible people, that's absurd, it would also render the provisions unconstitutional. The court has made clear that states can regulate their elections and empowers Congress to regulate how federal elections are held, but not who may vote in them. They're forcing states to keep non-citizens on their voter rolls, and it's a serious constitutional question that the Supreme Court needs to address. And the District Court and the DOJ, although not the Fourth Circuit, agreed that non-citizens can be removed under the general removal provision, presumably because they're not registrants, and going back to the quiet period. But the plain text of the statute confirms this. They go to the dictionary. Eligible and ineligible. We divide them into subsets. Who's a voter, who's not a voter? It's like, well, I know we have to get into this stuff because it's so complicated for them to understand the concept of a citizen, apparently. The statutory purpose of the NVRA does not protect non-citizens. Just look to the findings and purpose section 2. So stop protecting non-citizens from being removed from election that they're not supposed to be in the first place. Ignoring the implications of this reflects a serious error in reasoning in that case. And so that doesn't apply here. This is the juicy stuff for Supreme Court judges. They're like, getting into the nitty gritty. But we still have to see what the 25 states say about this too. So Virginia's non-citizen removal process is not systematic, as we saw earlier, which was prohibited. It was individualized. They checked the Facebook and everything, man. They're like, what are these people doing? Even if the quiet provision period were read to apply to non-citizens, even if you said it does, we didn't violate it. Bars removal of people done systematically, but that's not what we did. We did it in an individualized manner. We actually took people who declared themselves to be non-citizens. There is another step of this too, because the local registrar then did a manual review, person by person, to confirm the two people are the same. Then they contact each non-citizen by mail. They give them 14 days. They give a pre-printed form affirming citizenship, very easy. They say a reasonable person, another court has said, with an interest in voting is not likely to ignore this type of letter. Very simple. It's already just mail back the pre-addressed card. All you got to do, just sign it. So they send a notice of cancellation a second time. It's the very definition of an individualized process. It begins with a personal attestation of non-citizenship. They say, I am not a citizen. So we're not even searching them out. They raise their hands, and ends in the removal of a person only when they get two individualized letters to them offering an individualized corrective response. And the ad hoc process was similar, if not even more individualized. The process was limited to individuals who had provided a legal alien residency document to the DMV. So if they got legal alien residency, they're not a citizen. Then they searched. Then they used their unique alien registration number to verify their status. To ensure the people who had recently obtained citizenship were not removed, they then did a fresh search of save. The Fourth Circuit then put great weight on the fact that they used electronic comparisons. They said, well, they use computers, and so they used a computer system on their computer, and so therefore systematic. Well, do you have a folder on your hard drive called system? Yeah, there you go. You used a system then. So illegals back on the rolls. But the use of the electronic tools, they said, was systematic because they used a mouse and a keyboard. The Fourth Circuit and their additional reasoning for why the non-citizen removal is systematic is even less persuasive. It said the challenged program does not require communication or particularized investigation into any specific individual. What? But a letter is a communication, obviously, and registrars sent two of them to each specific individual, to them. So that is based on their alien identification number, which of course is particularized. So we need a stay. If we do not have a stay, if they force us to bring these 1,600 non-citizens back, Virginia will be irreparably harmed. And if you grant a stay and these people are kept off, the government will not be harmed at all. Nobody will be harmed. Not only will the Commonwealth be irreparably harmed absent a stay, so will its voters and the public at large. The injunction requires Virginia to put 1,600 self-identified non-citizens back on the rolls. The Fourth Circuit concluded that it could not know that the people removed were in fact non-citizens, but they failed to consider everything we did. Over 1,000 of the removed self-identified non-citizens were confirmed as non-citizens by fresh save searches that uses the federal government's database. Others voluntarily declared themselves to be non-citizens. The vast majority of the 1,600 that Virginia is required to place on the voter rolls are in fact non-citizens who cannot vote without committing a felony. felony under U.S. code, but they don't care. The district court minimized these concerns by wholly ignoring all of this. They said this court does not know that all the persons who were removed were non-citizens, but in the preliminary stage, doubt counsels for caution. Non-citizen voting drives honest citizens out of the process because your votes matter less. What does it matter? I mean, if anybody from anywhere can vote in our elections and they just send in a ballot from overseas that aren't matched against any number, or they're actual non-citizens who raise their hands and you let them vote anyways, what's the point? Do we even have a country? Citizens' right of suffrage can be denied by debasement or dilution of the weight of our vote. It should be every person gets one vote. Our votes count for 0.8, 0.9 because a bunch of other people have stolen a portion of them. Once this dilution occurs, there can be no remedy for legitimate voters. There's no do-over. There's no redress. The election occurs. And then the Democrats prosecute everybody who challenged them after their thievery. Plaintiffs contend, the government, the DOJ, that they're going to suffer irreparable harm. Well, because there could be some non-citizens who are removed. Not so. Even if a citizen was removed because he mistakenly checked the wrong box at the DMV and somehow missed both notices, he can still vote on the same day and cast a provisional ballot. 98% of provisional ballots are counted, and a person's prior removal from the rolls provides no basis to reject a provisional ballot. So as long as they attest to his citizenship in the same day registration, they're good. And that's a remedy here for them. So they're not going to be disenfranchised. They just have to show up and vote. Indeed, organizational plaintiffs, so the DOJ and others, they've identified only 3 named persons as citizens who were removed from the rolls. Okay, so they went through those 1,600 names and they said, oh, see, you do have some citizens on there, don't you? And they found 3. And of those 3, 1 has already voted, 1 has re-registered to vote, and 1 plans to same day re-register and vote in person on election day. And they've got their declarations. So they talked to Carolina, DD, Anna J. Norman, and these are 2 people. Plaintiffs' scanty evidence is far from demonstrating either that Virginia's process was unreliable or that any voter would be irreparably harmed. Okay, they've all figured it out. And also, the DOJ has unduly delayed bringing this complaint. Virginia's statutory non-citizen removal process was enacted and pre-cleared by the same DOJ in 2006. And they've been removing people since at least 2010. Yet even after Governor Youngkin issued this new order, the government, the DOJ, Biden-Harris, they waited to sue until October 7th, 2 months into the 3-month quiet period. The district court ignored their failure because they claimed that they didn't have enough information to sue because Virginia stonewalled them. Oh gosh, yeah. That's a good valid reason to sue someone? Okay. But the claim they have asserted under the NVRA accrued at the beginning of the quiet period, and so they've waited too long. The United States' only excuse for its tardiness is that the voting rights section of the DOJ was unaware of these removals until October. Oh, we just learned about it. They were too busy prosecuting Trump. Given that the media was widely reporting on this controversy, they should have known, if they even had a modicum of diligence. Well, they are government prosecutors. The Fourth Circuit also adopted their argument, saying that Purcell doesn't apply here because they were using the wrong law, but that argument cannot excuse their decision to wait. The decision to wait has serious and deleterious consequences for Virginia. By the time that the preliminary injunction hearing in this case took place, early voting had already been happening. None of this would have happened if they would have sued in August. Now, at most, the Supreme Court here should consider the nature of this 90-day quiet period and balance that against Purcell, and they caused a delay. They tell us running statewide elections is very complicated. Burdens increase as election days draw nearer. Requiring us to put 1,600 self-identified non-citizens back on the rolls is going to cause some complexities. Not only does the injunction force the registrars, so the requirement to put them back on, force them to re-roll literal non-citizens after the deadline, it also requires elect to take a bunch of burdensome actions. They ordered individuals to send letters to all of these people, rescinding the removal notices and issue guidance to registrars. Attempting to send notices and give last-minute guidance will create confusion and make things even more difficult. There is no way to guarantee that the 133 registrars will uniformly implement these rules. There's a lot of potential for confusion. There's going to be a massive influx of work for them. Every minute on this is going to hamstring our election. And finally, the court ordered that we send remedial mailings, apology letters, informing people that they have been improperly removed from the voter rolls and they're being restored to the rolls. That carries a serious risk of confusing non-citizens into thinking they can vote. That's the point, right? It is true that the mailing will state that non-citizens are not eligible to vote, but the plaintiff's entire legal theory is that people accidentally end up being removed from the rolls because they didn't read prior communications. The injunction also requires the Commonwealth to issue a press release stating that it was not allowed to remove them from the ballot. It would not be surprising if some non-citizens understood these statements as an authorization for them to vote. They got a ballot in their hand. And are they going to prosecute them for a felony? No. Not only would such a mistake potentially expose them to criminal charges, which is the real risk, it's almost like they're entrapping them, inducing them. Such court-introduced errors would severely undercut the public's faith in our electoral system. 1,600 potential felonies. All you got to do is send that ballot back in. Oh, you're a felon. The point of Purcell is not to do this. And so they say the court is likely going to grant review because this is a mess. The lower courts are divided on this very important issue of election laws and how this should work. The court is routinely granted cert on these cases, not only as the scope of the removal provision divided these lower courts, but it's an important issue. The rules surrounding these elections should be stable and knowable for voters. The current confusion around the NVRA makes the rules anything but clear by design, right? That's how they get all these people voting who should not be voting. States are unaware of when or whether they can even remove non-citizens from the rolls. You can't, otherwise the DOJ will come after you. They need to know with certainty whether they can remove non-citizens at any point, only outside of the quiet period, or never. When is it? And so for these reasons, we ask from the Office of the Attorney General in Virginia that you accept our case, Supreme Court, and stop them from ordering us to put these people back on the rolls. Allow a stay to permit the resolution of this case, and don't make us put them back on the rolls. And so they're joined by 26 states, Kansas, and then some. They say, look, this is ridiculous, okay? 3 weeks before an election, the DOJ filed a lawsuit saying that Virginia violated federal law by removing people from the rolls. They sued and filed their suits more than 60 days after the violation and weeks after voting had already begun. But the district court nevertheless agreed with the DOJ, injecting mass confusion into Virginia. And us states are concerned about this, saying the court should grant Virginia's emergency motion, Supreme Court, and restore the status quo, saying the court has been clear. The Elections Clause empowers Congress to regulate how federal elections are held, but not who may vote in them, and that it would raise serious constitutional doubt if a federal statute stopped a state from obtaining the information necessary to enforce its voter qualifications. But that's exactly what's happening here. The district court, a federal judge, is forcing Virginia to add people back on the voter rolls despite being removed because they're non-citizens. This sweeping interpretation converts a statute into a federal regulation, and it raises serious questions about the constitutionality of all of this. This court should accept Virginia's narrower and correct reading of the provision and interpret it so that they can remove people who shouldn't be on the rolls from the rolls. We got a bunch of states here who are joining in on this, and I'm sad to say that our useless attorney general in Arizona is not doing anything. Thanks for nothing, saying the states agree with the arguments advanced by Virginia, all 26 of them. April 20th, Congress passed the NVRA 1993, so eligible citizens could vote. 90-day period, as understood at the time. It does not protect non-citizens. And so we know the main points of this. 18 years ago, the people of Virginia, through their elected officials, created a lot of the same rules that we talked about in the states filings. Let's see how the states are concerned here. They say the historical record shows the framers intentionally chose to use the term manner of holding elections in the Constitution in order to deny Congress the power to establish the qualifications of voters. James Madison specifically stated that the right of suffrage is very justly regarded as a fundamental article of Republican government, and that to leave it open for the occasional regulation of Congress would have been improper. He also noted that to have reduced the different qualifications in the different states to one uniform rule would probably have been as dissatisfactory to some of the states as it would have been difficult to the convention. In other words, except for certain constitutional requirements that are not relevant here, the qualifications of voters are left up to the states, not to Congress. This court has already recognized that Congress can dictate the how, but not the who. And so a federal statute determines what we can do. The interpretation of the so-called quiet period urged by the respondents necessarily results in Congress forcing a state to allow voting by non-citizens over the objection of the state. Talk about your overpowering federal government. It converts the NVRA federal statutes into a federal mandate now that states allow non-citizens to vote in violation of state law and in violation of federal law itself whenever a putative voter's non-citizenship status is discovered within 90 days of the election. So as long as you can squeeze them in there within the 90 days, they're going to be on the rolls. If that is really what this law requires, the statute's totally unconstitutional. Congress lacks the authority to require non-citizen voting. This court recognized in another case that setting voter qualifications would be meaningless if states states didn't have the ability to enforce those requirements. But if the government were correct, it would mean that Virginia has no power to enforce its prohibition on non-citizen voting whenever they discover non-citizens on the voter rolls. Any assertion that they are not seeking to prevent Virginia from enforcing its voter laws is undercut by their own arguments. They said that the quiet period does govern removals, including over non-citizens. But essentially what this does, it means that the mailing and the injunction leaves Virginia with no way to enforce its own laws. You're stripping the sovereignty away from the states, which is what the federal government likes to do. It mandates non-citizen voting. Very easy. All you have to do to reverse that, just interpret the narrow interpretation is what should apply. Interpreting the NVRA to mandate that states retain non-citizens is inconsistent with the rest of federal law. No one else is mandating this, and so this court should reject this interpretation. The upcoming election is hotly contested, has caused division around the country. Perhaps the division would be lower if the federal government were not interfering with the election via last-minute attacks on state efforts to police voter qualifications. The U.S. government, Biden and Harris's DOJ, sued Virginia on the eve of the election, weeks after early voting already began, despite knowing about the Commonwealth's supposed NVRA violation for at least 60 days before. This court, the Supreme Court, should reject the effort to change the rules in the middle of the game and restore the status quo. The framers understood the problems associated with federal control over a state voter qualification law. Problems on full display here. The Constitution leaves decisions about voter qualifications to the people of Virginia, and the people of Virginia have decided that non-citizens are not permitted to vote. And so this court should reject the government's attempt to keep them on the rolls in Virginia, grant the application by Virginia, and issue a stay, stopping the lower court from forcing them to put these people back on the rolls.